Hello everyone, welcome to the channel OCS by Ranjan. आमर OCS by Ranjan ऐप रे टेस्ट सीरीज स्टार्ट हो सारी आपण मैंने जॉइन करें एवं आप रे थिबा चैट बॉक्स रे डिटेल्स आपण मैंने सार को सह चैट करें किंबा नंबर टी लिखि नियंतु सार को व्हाट्सएप करें 7978405181 टेस्ट सीरीज जॉइन करें जहाद्वारा आपणकर प्रिपारेसन टी बेस्ट रहिबो एवं भलो यूनिवर्सिटी मिल पार। प्रीवियस वीडियो रे LLM CPET क्वेश्चन पेपर 2020, 21 एवं 22 ऑलरेडी डिस्कशन हो सारी आपण मैंने चाहिए प्रीवियस वीडियो रे देखि पारिबे। चलंतु एबे डिस्कस करिबा CPET LLM 2023 क्वेश्चन पेपर। क्वेश्चन नंबर 1, who among the following is considered to be the chief exponent of historical school? यार ठीक आंसर टी हेबो ऑप्शन बी। क्वेश्चन नंबर 2, who said that source of law include the material from which the judge obtains rule for deciding cases? यार ठीक आंसर टी हेबो ऑप्शन डी। R.W.M. Dias, a renowned legal scholar, defined sources of law in a broad sense, encompassing not only formal rules but also the materials that judges drawn upon when making decisions. This includes precedents, customs, legal principles, and even scholarly writings. Diaz' view acknowledges the practical reality that judges don't operate in a vacuum. They rely on a range of sources of inform their judgments. Question number 3, the limit of jurisprudence defined published in 1945 was written by option A, Salmond. Sir John Salmond, a prominent legal scholar and jurist, authored The Limits of Jurisprudence Defined. This work is a significant contribution to the field of jurisprudence. Exploring the boundaries and scope of legal theory, Salmond's analytical approach and clear exposition of complex legal concepts have made this book a classic text in legal education. Question number 4, only human beings can have interests and rights, and that a corporation is only a legal device of formula which will every complex dual relation to be understood easily. Which theory says that? ठीक आंसर टी हेबो ऑप्शन सी, fiction theory. The fiction theory posits that corporations are merely artificial entities created by the law. They are treated as persons for certain legal purposes, but this is an fiction, a legal construct, because only natural person, human beings, can truly possess rights and interests. The corporation is simply a tool to simplify complex legal relationships. Question number 5, who observed that ownership denotes the relation between a person and a object forming the subject matter of ownership? ठीक आंसर टी हेबो ऑप्शन डी, सॉरी, John Salmond, a prominent legal theorist, provided this classic definition of ownership. It highlights the relationship between the owner and the thing owned, person and object, emphasizing that ownership is a connection, a bundle of rights, rather than just a physical possession. Question number 6, who opined that the divine of law and the human law was as law proper? ठीक आंसर टी होची ऑप्शन सी, जॉन ऑस्टिन. John Austin, a key figure in a legal provision, distinguished between law properly so-called and law improperly so-called. According to Austin, divine law, God's law, and human law, positive law enacted by sovereign, are law property so-called because they are commands backed by sanctions. Other rules like customary law or moral rules are not law properly so called as they lack a sovereign source. Question number 7. Who made the statement that law is not only a set of rules but also a method or technique of harmonizing conflicting interest? यार ठीक आंसर टी हेबो ऑप्शन ए Rasco Pound, a leading proponent of sociological jurisprudence, viewed law as a tool of social engineering. He emphasized that law's primary function is to balance competing individual and social interest, minimizing friction and promoting social harmony. Pound's interest theory focuses on how law identifies and protects various types of interest in society. Question number 8. Which of the following cases completed 50 years in 2003? ठीक आंसर टी हेबो ऑप्शन ए केशवानंद भारती वर्सेस स्टेट ऑफ केरला. This landmark case of Kesavananda Bharati State of Kerala was decided on April 24, 1973. April 24. It is a pivotal case that shaped the basic structure doctrine the Indian Constitution, limiting the power of Parliament to amend fundamental features of Constitution. Since 2023 marks 50 years since the decision. This is the correct answer. Question number 9. The word law in Article 21 of the Constitution does not mean merely an enacted piece of law but must be just, fair and reasonable law. In which of the following cases the Supreme Court held this view? ठीक आंसर टी हेबो मेनका गांधी वर्सेस यूनियन ऑफ इंडिया. द मेनका गांधी वर्सेस यूनियन ऑफ इंडिया is a watershed movement in a imposition of Article 21 right to life and personal liberty. The Supreme Court held that the law under Article 21 does not simply mean any enacted law, it must be fair, just and reasonable. This broadened the scope of Article 21, ensuring that producers depriving a person of their life or liberty must adhere to principle of natural justice due to process. Question number 10. Referring to Article 32 of the Constitution, who said that if I am asked to name any particular article in this Constitution as the most important article without which this Constitution would be nullity? ठीक आंसर टी हेबो ऑप्शन डी डॉक्टर B.R. Ambedkar. Dr. B.R. Ambedkar, the chairman of the drafting committee of the Indian Constitution, considered Article 32 right to constitution remedies as the most important. This article guarantees the right to move the Supreme Court for the enforcement of fundamental rights. He felt it was the heart and soul of the Constitution because it provides the mechanism to protect all the rights. Question number 11. Which one of the following rights are available only to the citizens within the territory of India? ठीक आंसर टी हेबो ऑप्शन बी फ्रीडम ऑफ स्पीच. This question is tricky because it has a typo. This question should ask which of the following rights available only the citizens within the territory of India. Here, why freedom of speech is the correct answer. Assuming the typo is corrected, Article 19 of the Indian Constitution guarantees the right of freedom of speech and expression. This specifically for the citizen of India, not for the foreigners. The other option, while important, are available to both citizens and non-citizens within India. Question number 12. In every event of vacancy in the offices of both the President and the Vice President of India, who among the following performs the duty of President of India? यार ठीक आंसर ऑप्शन गुड़ाक देखीदेबा चीफ Chief Justice of India, Speaker of Lok Sabha, Chairman of Rajya Sabha, Solicitor of General of India. ठीक आंसर टी हेबो ऑप्शन ए चीफ जस्टिस ऑफ इंडिया because the order of succession of the for the office of president of India is first president, then vice president and then chief justice of India. If president and vice president office are vacant, the chief justice of India assumes the duties of the president. Question number 13. Which article of the constitution puts a bar to interference by courts in electoral matters notwithstanding anything in constitution? ऑप्शन गुड़ाक देइछे आर्टिकल 324, आर्टिकल 325, आर्टिकल 329 and 328. ठीक आंसर टी हेबो आर्टिकल 329 because article 329 of the Indian constitution specifically bars court from interfering in electoral matters once the election process has started. This includes matters like validity of elections, delimitation of constituencies, etc. The idea is to ensure smooth and uninterrupted elections. Question number 14. As per Article 356 of the Constitution, if the President of India is satisfied that a situation has arisen in which government of state cannot be carried on in the accordance with the provisions and the Constitution, he or she may issue the proclamation of state emergency. It can be done on receipt for a report from option A, governor of the state. Otherwise, Article 356 deals with the president's rule in a state. The president can declare president's rule if they are satisfied that the state government cannot be carried on in accordance with the constitution. This satisfaction can be based on a report from the governor of state or otherwise meaning from other source as well. Question number 15. The Universal Declaration of Human Rights was adopted by the United Nations General Assembly through a resolution in its third session on option गुड़ाक देइछि 25th June 1945, 10th December 1948, 15th August 1947, 26th January 1950. यार ठीक आंसर हेबो 10th December 1948 because the Universal Declaration of Human Rights UDHR was adopted by the United Nations General Assembly on December 10, 1948 on its third session. This is a landmark document setting out fundamental human rights to be universally protected. Question number 16. In which year of the National Convent on Civil and Political Rights was enacted? ऑप्शन गुड़ाक देइछि 1948, 1950, 1966 and 1968. या ठीक आंसर टी हेबो 1966 because the International Convent on Civil and Political Rights ICCPR is a treaty adopted by the United Nations General Assembly on December 16, 1966. The entered into force on March 23, 1976. This convent commits participating centuries to respect the civil and political rights of individuals, including rights to life, liberty, freedom of speech, etc. Question number 17. Who was the first chairperson of the National Human Rights Commission? ठीक आंसर टी होची ऑप्शन बी जस्टिस रंगनाथ मिश्र. Justice Ranganath Mishra was the first chairperson of National Human Rights Commission NHRC of India. The NHRC is an independent body tasked with the protection and promotion of human rights in India. Question number 18. On the 20th anniversary of adoption of UDHR in 1968, where the first World Conference of Human Rights was held. ठीक आंसर टी होची तेहरान. The first World Conference on Human Rights was actually held in Vienna in 1993, not in the Tehran in 1968. However, 1968 was the 20th anniversary of the UDHR and it was marked by the International Conference on Human Rights in Tehran, Iran. This conference focused on reviewing the progress made since adoption of the UDHR and formulating further strategies. Question number 19. In which year of the Protection of Human Rights Act was enacted? ठीक आंसर टी होची ऑप्शन डी 1993. The Protection of Human Rights Act was enacted in India 1993. This act established the National Human Rights and State Human Rights Commission, providing a legal framework of the protection and promotion of human rights in the country. Question number 20. Which of the following sections of the Indian Penal Code deal with acts done by several persons in furtherance of common intention? यार ठीक आंसर टी हम ऑप्शन सी सेक्शन 34. Sorry, because section 34 of the Indian Penal Code deals with the act done by several persons in furtherance of a common intention. It states that when a criminal act is done by several persons in furtherance of common intention, each of such person is liable as if he alone had done by the act. Question number 21. Section 120A of the Indian Penal Code defines option A criminal conspiracy. Section 120A of the IPC defines criminal conspiracy. It states that when two or more persons agree to do or cause to be done an illegal act or an act which is not illegal by illegal means, such an agreement is designated by a criminal conspiracy. Question number 22. The act or mission that constitute indirect way in the indirect participation in a crime is known as option B. Option B. The act or omission that constitutes an indirect way of participating in a crime is known as criminal conspiracy. It involves an agreement between two or more people to commit an illegal act even if they don't directly participate in an act itself. Question number 23. Section 82 of the Indian Penal Code, which speaks about Dolly in caps, refers to option A act done by a child under 7 years age. The Latin term dolly in caps means incapable of committing a crime. Section 82 of the IPC Indian Penal Code deals with this concept and specifically states that nothing is an offence which is done by a child under 7 years of age. This is based on the presumption that child below this age lacks of understanding and maturity to form the necessary criminal intent. Question number 24. Section 354 of Indian Penal Code constraint provision regarding. ठीक आंसर टी हेबो ऑप्शन डी outragging the modesty of a woman. Section 354 of the Indian Penal Code deals with specifically with assault or criminal force to a man with intent to outrage her modesty. While related to sexual offence, it doesn't encompass all sexual offence like rape or sexual harassment, which are covered under other sections. Question number 24. The Supreme Court had a opportunity to examine the exception of grave and sudden provocation at Grit length in which of following cases? Option A, KM Nanavati versus State of Maharashtra. This case, KM Nanavati versus State of Maharashtra 1959, is a landmark case in Indian legal history that extensively discussed the concept of grave and sudden probation as an exception to murder. This case involved a naval officer who shot his wife's lover, claiming he was proved by a sudden confession of adultery. Question number 26. In which of the following cases the concept of interim confession was evolved? ठीक आंसर टी हेबो ऑप्शन सी. The concept of interim compensation in cases of sexual harassment and assessed was evolved by the Supreme Court in the case of Buddhisata Gautam versus Subhra Chakrabarti 1996. This case recognized the need to provide immediate relief to victims even before the trial is complete. Question number 27. Which of the following theories is based on the principle of an eye for an eye, a tooth for a tooth? ठीक आंसर टी हबो ऑप्शन सी. Retributive theory. The retributive theory of punishment is based on the principle of an eye for an eye, a tooth for a tooth. It suggests that punishment should be proportional to the crime committed and that offenders should be punished for their wrongdoing. This theory focuses on justice and revenge rather than prevention or reform. Question number 28. Who made the observation that just as the criminal law consists of a body of rules establishing specific offence, so that the law of torts consists of a body of rules establishing specific injuries? ठीक आंसर टी हेबो ऑप्शन बी. John Salmond, a renowned legal scholar, made this observation. He emphasized that just a criminal law defines specific offence, the law of torts defines specific injuries that are actionable in court. This highlights the focus on specific harms suffered by individuals in tort law. Question number 29. Which of the following cases clearly established in favor of law of tort? ठीक आंसर टी होची ऑप्शन सी. Because it is a landmark case in the development of tort law, it established the principle that the right to vote is a legally protected right and any wrongful interface with that right actionable. Even if no actual damage is suffered, this case significantly advanced and recognition of individual rights and the availability of legal remedies for their violation. Question number 30. In which of the following cases the rules of strict liability was laid down? ठीक आंसर टी होची ऑप्शन बी. It is a foundational case for the rule of strict liability, also known as absolute liability. This case establishes that a person who brings something dangerous onto their land that is likely to cause harm if it escapes is strictly liable for any damage caused by its escape, regardless of fault. This principle applies to inherently dangerous activities or substances. Question number 31. So far as tort is concerned, with one out of the following is correct. ठीक आंसर है ऑप्शन ए. A remedy by way of damages is essential ingredient of tort. Damages are a fundamental element of most tort. A tort is a civil wrong that causes harm to another, and the primary remedy for a tort is typically monetary compensation. Compensation means damage to their injured party. While other remedies like injunctions might be available in some cases, damages are the most characteristic and essential ingredient. Question number 32. An accident is one out of ordinary course of things, something so unusual as not to be looked for by a person of ordinary prudence is said to be option C. Because the definition provided describes an inevitable accident, this refers to an event that occurs unexpectedly and despite reasonable precautions taken by the person involved. It essentially means an accident that could not have been reasonable avoided. Question number 33. MC Mehta versus Union of India talked about which kind of liability? ठीक आंसर होची ऑप्शन सी एब्सोल्यूट liability. This case, also known as the oleum gas leak case, led to the development of the principle of absolute liability in India. This liability applies to the industries engaged in hazardous or inherently dangerous activities. It's stricter than strict liability, holding that an enterprise engaged in such activities is liable for any harm caused, regardless of whether it looked reasonable case or not. There are virtually no exceptions once harm is established. Question number 34. Which of the following is not necessary in tort for the defamation? ठीक आंसर टी होची ऑप्शन डी. Because while it's more common that defamatory statements are made initially, the key element in defamation is not intention to refer the plaintiff, but rather whether a reasonable person would understand the statement to be about plaintiff, even if the speaker didn't intend to refer the plaintiff. Question number 35. A contract is an ठीक आंसर टी हेबो ऑप्शन बी. Agreement enforceable by law. While a contract does involve premises, the essential defining characteristic of a contract is that is an agreement that is a legal enforceable. Not all the promises are contracts. All contract requires offer, acceptance, consideration, usually something the value exchanged, and intention to create legal relation. Question number 36. The communication of an acceptance is complete as against the proposer. ठीक आंसर टी हेबो ऑप्शन सी. When it is put in the course of transmission so as to be out of acceptor's power. Question number 37. Question number 37. In which of the following cases the doctrine of frustration was laid down? ठीक आंसर टी हेबो ऑप्शन बी. It is a foundational case for the doctrine of frustration of contract. This case involved a music hall. The one down before a scheduled concert. The court held that the contract was frustrated because the continued existence of the hall was a necessary condition of performance, and its destruction made performance impossible. Question number 38. A quasi-contract arises from option C. Principle of natural justice. A quasi-contract is not a contract at all in the true sense. It is an obligation imposed by law, not based on agreement of the parties but on principle of the equality and fairness, often rooted in natural justice. It aims to prevent unjust enrichment where one party would unfairly benefit at the expense of each other. Question number 39. What is the continuing guarantees? ठीक आंसर है ऑप्शन सी, ए guarantee which extends to a series of transactions. Question number 40. Which section of the Indian Contract Act deals with agreement in restraint of legal proceedings? ठीक आंसर है ऑप्शन बी, section 32. Because section 32 of the Indian Contract Act 1872 deals with agreements in restraint of trade. While not specifically addressing legal proceedings, it covers agreements that restrict a person's freedom to engage in a particular trade or profession, which can indirectly affect legal proceedings. Question number 41. As per section 303 of the Code of Criminal Procedure, any person accused of an offence before a criminal court or against whom proceeding and initiated under this code may have the right to be defended by option A, a pleader of his choice. In section 303 of the Code of Criminal Procedure gives an accused person to fundamental right to choose their own legal representation. This right considered essential for ensuring a fair trial and protecting the accused's rights. Question number 42. Which chapter of the Code of Criminal Procedure deals with reference and revision? ठीक आंसर है ऑप्शन डी, Chapter XXX of the CRPC 1973 specifically deals with reference and revisions. It covers the power of the High Court to call for records of lower courts and make appropriate orders in case of legal errors and irregularities. Question number 43. The concept of plea bargaining as an alternative resolution method is being administered by our criminal code since the year 2005. Because plea bargaining was introduced into Indian criminal justice system through the Criminal Law Act of 2005, which came into force in 2005, it's a process where the accused negotiates with the projection for lesser punishment in exchange of a guilty plea. Question number 44. Which of the following section of the Code of Criminal Procedure was incorporated in 2009 through an amendment specifically to provide representation to victims and their families? ठीक आंसर है ऑप्शन बी, Section 375A. Section 375A was inserted into the CRPC in 2009 as a part of amendments focused on victims' rights. It specifically deals with the victim compensation scheme, directing state governments to establish funds for compensating victims of crime and their dependents who have suffered loss or injury as a result of the offence. Question number 45. Section 133 of the Code of Criminal Procedure deals with option C, order to removal of public nuisance. Question number 46. The Court of Magistrate of the first class may pass a sentence of imprisonment for a term not exceeding. And ठीक आंसर है 3 years. A magistrate of the first class can impose a sentence of imprisonment up to a maximum of 3 years according to the Criminal Procedure Code CRPC. Question number 47. Which section of the Indian Evidence Act provides that all documents produced for the inspection of the court, such documents are called documentary evidence? ठीक आंसर टी हेबो ऑप्शन बी सेक्शन 3(2). Section 3(2) of the Indian Evidence Act defines documentary evidence as all documents produced for the inspection of the court. This includes any matter expressed or described upon any substance by letters, figures or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. Question number 48. Which section of the Indian Evidence Act provides for the presumptions as to dowry death? ठीक आंसर टी हेबो ऑप्शन सी सेक्शन 113B. Section 113B of the Indian Evidence Act deals specifically with the presumptions as to dowry death. It states that if a woman dies within 7 years of a marriage and there is evidence that she was subjected to cruelty or harassment by her husband or his relatives in connection with any demand for dowry, the court shall presume that such death was dowry death. Question number 49. According to section 133 of the Indian Evidence Act, who shall be a complainant witness against an accused person? ठीक आंसर टी हेबो ऑप्शन ए because section 133 of Indian Evidence Act specifically address the competency of accomplice as a witness. It states that an accomplice is a component witness against accused person and conviction is not illegal merely because it is based on the uncorroborated testimony and accomplice. However, the court as a matter of produce generally requires corroboration of an accomplice's testimony. Question number 50. As per section 41 of the Indian Evidence Act, which judgment are relevant even against strangers by making them binding? ठीक आंसर टी हेबो ऑप्शन बी judgment in rem. Judgment in rem are judgment that determine the status of a thing as opposed to a judgment against a person. They are binding on the whole world, not just the parties involved in the case. Examples including judgments relating to matrimonial status, example divorce, admiratory matters, rights over a ship, probate validity of a will, declaration of legitimacy, insolvency. Question number 51. The definition of environmental pollution as provided in the Environment Protection Act is option A Question number 52. Applying the doctrine of public trust, in which of the following cases the apex court said that state as trustee of all natural resources is under a legal obligation to protect the natural resources and these natural resources are meant for public use, cannot be converted into private ownership? ठीक आंसर टी हेबो ऑप्शन बी MC Mehta versus Kamalnath. The doctrine of public trust is legal principle that holds that certain resources like water, air and forest are held by the government interest for the benefit of the public, the government can't be abided this trust by transferring these resources to private ownership of commercial purpose. In this landmark case where the Supreme Court of India explicitly applied the doctrine of public trust, this case involved the construction of motel of banks of the river which interfered with the natural flow of the river. The court held that the state is a trustee of natural resources and is under a legal obligation to protect them for a public. Question number 53. Intergenerational equity was discussed in which of the following conference or declarations? ठीक आंसर होची ऑप्शन बी. Because intergenerational equity is the concept of that present generation should not use of or damage natural resources in a way that future generation will be unable to benefit for them. Question number 54. In which year of the United Nations adopted the 2030 Agenda for Sustainable Development? ठीक आंसर होची 2015 because the 2030 Agenda for Sustainable Development, including the Sustainable Development Goals, was adopted by the United Nations General Assembly in September 2015. Question number 55. EIA stands for Environmental Impact Assessment. Option A. Question number 56. Order, which means the formal expressions of any decision of a civil court which is not a decree, is defined under option C. Because section 214 is the Code of the Civil Procedure CPC 1908 defines order as the formal expression of any decision of a civil court which is not a decree. Question number 57. At the district level, which court has the original as well as appellate jurisdiction? Option D. The Court of District Judge, which is a principal court of civil jurisdiction. Question number 58. On default is filing of written statement under order VIII pronounced of judgment is option D. Question number 59. Res judicata relates to a matter already adjudicated or matter in which decision is already there. Which section of the Code of Civil Procedure deals with this? Option गुड़ाक देइछि section 10, 13, 11 and section 15. ठीक आंसर टी हेबो section 11. Section 11 because res judicata is a fundamental principle in law that prevents the re-litigation of matters that have already been decided by a court. It aims to prevent multiplicity of suits and ensure financially in litigation. Question number 60. Which section of the Copyright Act provides the provision for the punishment for infringement of the copyright? ठीक आंसर टी हेबो ऑप्शन ए section 63. Section 63 of the Copyright Act 1957 prescribes that punishment for the copyright infringement. It provides for imprisonment and fines for knowingly infringing copyright in a work. Question number 61. Intellectual property protects the use of information and ideas that are of commercial value. Option A, commercial value. IPR are primarily designed to protect commercial interests. They grant exclusively rights to creators and inventors to be control and use exploration to their creations, allowing them to profit from their work. Question number 62. Universal Copyright Convention UCC as an alternate to Berne Convention was adopted in 1952 in Geneva. Option C, Geneva. Question number 63. How long do the patents usually last for? Option गुड़ाक दीजिए 10 years, 20 years, 30 years and 40 years. ठीक आंसर टी हम 20 years. In most of the countries, including India, the standard patent term for inventions is 20 years from the date of the filing application. Question number 64. Which of the following could not be registered as a trademark? Option C. The mark represents the natural or technical shape of the good. 65. Originally under the Hindu Marriage Act 1955, divorce was based on option D, fault theory only. Hindu Marriage Act 1955 initially based divorce on the fault theory. This meant that divorce could only be granted if one party proved that other party had to committed matrimonial offense like adultery, cruelty, desertion. Question number 66. In which of the following cases of Supreme Court held that marriage of all persons who are citizens of India belonging to various religions should be made compulsorily registerable in their respective states where the marriage is solemnized? ठीक आंसर टी हेबो ऑप्शन डी. Question number 67. The dissolution of Muslim Marriage Act is enacted in the year 1939. Question number 68. Adultery as matrimonial offence is punishable under which section of the Indian Penal Code? Option गुड़ाक देइछि section 494, 497, 498, 498A. ठीक आंसर टी हेबो ऑप्शन बी section 497. Section 497 of the Indian Penal Code dealt specifically with the offence of adultery. However, it's crucial to note that the section has been struck down by the Supreme Court of India in the case of Joseph Sain v. Union of India 2018. Adultery is no longer a criminal offence in India. Question number 69. As per the Companies Act 2013, a company eligible for corporate social responsibility norms should have ठीक आंसर टी हेबो ऑप्शन सी नेट वर्थ ऑफ द कंपनी टू बी रुपी 500 crore or more. Question number 70. Which section of the Companies Act 2013 provide for the constitution of National Company Law Tribunal? ठीक आंसर टी हेबो ऑप्शन बी section 408. Section 408 of the Companies Act 2013 deals with the constitution of National Company Law Tribunal. The NCLT is a quasi-judicial body that has replaced the Company Law Board, has been vested with the powers relating to the regulation and management companies. Question number 71. Which of the following acts incorporated the concept of one person's company? ठीक आंसर टी हेबो ऑप्शन डी the Companies Act 2013. The concept of a one-person company was introduced in Companies Act 2013. It allows a single individual to form a company, providing a separate legal entity to sole proprietorship business and enabling them enjoy the benefits of limited liability and corporate structure. Question number 72. Which section of the Companies Act 2013 defines the term limited liability company? ठीक आंसर होची ऑप्शन बी सेक्शन 222. Section 222 of the Companies Act 2013 specifically defines that what a limited liability company is. Context of act, it outlines a key characteristics and structure of such companies. Question number 73. As per the Companies Act 2013, the minimum members necessary for the establishment of the public company are 7. Question number 74. Which section of the Industrial Dispute Act provides that the central government may, by notification in a official gazette, constitute one or more national tribunals for the adjudication of industrial disputes? Here ठीक आंसर है ऑप्शन ए सेक्शन 7A. Section 7A of the Industrial Disputes Act 1947 empowers the central government of established national tribunals. These tribunals are meant to resolve industrial disputes that are national importance or involve substantial questions of law. This notification in the official gazette formally announced the establishment of such tribunals. Question number 76. As per the section 22(1), the Industrial Disputes Act, a person employed in a public utility serve can go on a strike in breach of contract. ठीक आंसर है ऑप्शन ए within 14 days of giving such notice. Section 22(1) of the Industrial Dispute Act 1947 mandates the employees in public utility services must give a strike notice within 14 days before doing a strike. This provision aims to prevent sudden disruptions of essential services. Question number 77. Which section of the Transfer Property Act speaks out the rule against perpetuity? ठीक आंसर है सेक्शन 14 ऑप्शन सी. Section 14 of the Transfer of Property Act 1882 deals with the rule against the perpetuity. This rule essentially prevents tying up the property for an indefinite future by restricting the creation of future interest that vest too remotely. Question number 78. In the transfer of property, the phrase no one can appropriate and reprobate at the same time applies to option A, doctrine of election. Question number 79. Doctrine of a part performance as provided under section 53A of the transfer property. ठीक आंसर है ऑप्शन ए is applicable only when the contract is in writing. Question number 80. As for section 118 of the Transfer of Property Act, when two persons mutually transfer the ownership of one thing for the ownership of another, neither thing or both things being money only, the transaction is called option D, exchange. Because section 118 of the Transfer Property Act 1882 specifically defines an exchange as a transaction whether two persons mutually transfer the ownership of one thing for the ownership of another, with neither thing being money only. Essentially, it's a better system for immovable property.